The fired campus police officer who shot and killed a driver during a traffic stop in Cincinnati has been released from jail after posting $1 million bail. Tenzing has pleaded not guilty to murder and voluntary manslaughter charges in the shooting death of Samuel DuBose. Tenzing's attorney says his client is being railroaded. But yesterday on America's Newsroom, the prosecutor said he made the right decision.
I'm going to do what's right. If it was clearing the cop, I would have cleared the cop. Wherever the facts fall, the chips go, that's the way it works. That's the way I am. You know, I want to be able to look myself in the mirror every day, and I know that this is the right call.
Tom Kenneth is a former federal prosecutor. Bob Bianchi, criminal defense attorney, former chief county prosecutor. Bob, first to you, we're going to put the facts of the case back beside things in terms of what has happened of the video and those things that we debated yesterday. Let's look at what the prosecutor has been saying, though. He said that Tenzing executed this suspect, Mr. DuBose. He also said he should have never been a police officer. That seems pretty incendiary to be coming from a prosecutor even before trial.
Well, this is something that's been going on now with these high-profile cases. It's outrageous. It is a violation of every ethics rule. I was a head county prosecutor. I know these rules inside and out. These cases are to be tried in a courtroom, not the court of public opinion. To throw out these incendiary comments like this skews the criminal justice process. It's being done to score political points. It creates an unfair environment for the defense. And more importantly, it's going to hurt the prosecutor's case when the defense is going to use that as a reason that they can't get a fair jury pool. It's an outrageous thing to do, and charges should be brought for these things.
Tom, that's what I was going to ask you in the sense that it reminds me in some ways almost of the Duke lacrosse case, the kind of rhetoric we're hearing out of the prosecutor in this, but it in some ways makes it easier for the defense attorneys later on, right?
Well, it's going to make it easier for them to, as Bob pointed out, to argue a change of venue motion. In other words, this is already a case that has garnered a tremendous amount of publicity, and given everything that's went on the last 12 months with Ferguson and the Garner case, it's going to garner a whole lot more publicity. You may not be able to guard against that. I mean, trials are matters of public record. The media has a right to report on them, but as a sitting district attorney, you are subject to higher standards than even a defense counsel is. So you're not a heated partisan. You're supposed to dispassionately present the evidence. He has no business making appearances on the cable news networks and so forth, trying to poison the case or get an advantage in a case like this. One press conference, fine, but ended there.
You said something interesting. You said Ferguson, and you also said Baltimore and those things. Take a listen to what the defense attorney for the police officer, Mr. Tenzing, had to say last night on the Kelly file about that.
They've tried this case in the press, and part of it, I think, is because of the fear that there may be a repeat Ferguson, Missouri, or Baltimore, Maryland here in Cincinnati, Ohio, and they're attempting to keep a lid on it by throwing my client under the bus.
And there's history in Cincinnati. 2001, there was an unarmed black suspect shot. There was a number of riots, a lot of violent riots in Cincinnati after that. Is this one of these things that it may be fine to try to quell the anger right now by this fiery rhetoric, but in the end it backfires if all of a sudden this police officer is acquitted?
No, absolutely not. And I've had high-profile shootings of minority people. What you do is you bring those community members in, you assure them you're going to dot I's and cross T. Hopefully you've established a relationship with them before. But the bottom line is these cops are now this cop is now a defendant. He is entitled to the presumption of innocence, proof beyond a reasonable doubt, in a courtroom, not the court of public opinion. And what the prosecutors, and that's why there's rules, ethics rules, very clearly stating what it is that people like me could and couldn't do. I would never think of going out into the public and using this kind of verbiage. As Tom has stated, what you do is you go in, you give a brief press conference to let the public know what's going on, and then you say anything you need to hear. You can go into the courtroom, and that's where we're going to make our case, not on TV. Outrage.
And a lot of questions over the release of that video as well, once he'd already charged him. Tom, Bob, we'll leave it there. Appreciate it, guys. Thank you.
Thank you
so much.